Last Thursday, R.Kelly and his new lawyer, Jennifer Bonjean, filed motions with the court asking the judge to throw out the case against him. Let's get into the details. We're talking about R.Kelly's motions recently filed in court. This will be another solid video, so make sure you like button, subscribe if you haven't already, and turn on notifications so you never miss a new video when it drops.
Quit playing. Use your common sense. Don't forget the blogs. Forget how you feel about me. Hate me if you want to, love me if you want, but just use your common sense.
As you likely know by now, R.Kelly went to trial on a racketeering charge and 8 counts of violating the Mann Act last fall. Hales recently filed a motion asking that he be acquitted, or at a minimum, he be given a new trial. A motion for an acquittal is based on the argument that the evidence at trial was insufficient for a conviction. So R.Kelly and his lawyer would be essentially arguing that the federal prosecutors did not present sufficient evidence to secure a conviction.
And they are doing that, yes, to plead around the statute of limitations. But even more problematic in my mind is they used this statute in order to overwhelm the jury with other crimes evidence or other bad act evidence. It doesn't even have to be another crime. So really what they're doing is putting someone's life on trial. And that ends up being not really a fair fight. There's allegations that date back 30 years, and there are sometimes it's very difficult for particularly high-profile people. 30 years. Oh, do I even know this person? Where was I? How can I defend against that?
In terms of the government being allowed to bring in so many Jane Does and John Does to testify against him that are not named the indictment, especially the John Does, because to hear from the 2 males that R.Kelly had a relationship, what does that have to do with the charges? What does that have to do with any of the Jane Does?
So really what they're doing is putting someone's life on trial.
What is your rationale for introducing the testimony of the 3 uncharged victims?
The testimony of Young, Dunning, and Wolf, as Justice Burke found, was directly probative of defendant's state of mind.
Why wasn't that accomplished with the 3 women who were complainants? I mean, that for me is the problem. You already have 3 women who give you 3 different types of stories of the horrors they allege they experienced with him. I think you've covered that. So to pile on with 3 uncharged complainants, 3 uncharged victims, is leaning really close to that propensity line.
It was relevant to defendant's intent. As Your Honor pointed out, intent was hotly contested below.
I don't understand how that wasn't established through Mann.
Because
he had a 5-year relationship with him after the assault.
Because Mann's allegations were not so unambiguous that there would have been no doubt in a juror's mind that defendant intended the forcible element of the first-degree rape. Again, when Justice Burke...
You're saying that you wanted to prove what he did with Mann by introducing the testimony of those other 3 women.
No, certainly not. Mann's allegations would have established, if believed, would have established the elements of the offense.
Where the women were of the uncharged crimes were not the victims for which were being prosecuted, though. Where was the balancing that's supposed to go on in Molyneux? This was incredibly prejudicial testimony, no?
Well, no, respectfully, Your Honor, it wasn't prejudicial for 2 reasons. One, the court gave extensive limiting instructions. 3 times the court explained to the jury...
The fact that there's instructions doesn't mean it's not prejudicial.
But here we know it wasn't...
I'm being charged with 3 rapes. And here come 3 other women who claim I did the same thing to them, but I'm not being charged with that. That's prejudicial.
Well, it's not prejudicial.
So the question is, does that prejudice, is that outweighed by some probative value that supersedes that?
Respectfully, Your Honor, it wasn't prejudicial here, and we know that.
Opposing counsel referred to the Molyneux rulings in this case as unprecedented. What cases do you rely on under New York law that actually constitute precedent for the court's rulings in this case on the Molyneux issues?
Well, parsing the Molyneux evidence, no one would quibble with the admissibility of the uncharged offenses as to man. Ample case law, which we...
I'm talking about the other three women.
Right. As to Young, Dunning, and Wolf, again, I think Vargas is a perfect illustration of precisely why we were permitted to put forth the evidence here. It's well understood that Molyneux evidence can shed light on a defendant's state of mind and intent.
So you're really arguing that this was not overkill? I mean, there were certain items in the Sandoval that I thought, okay, that's fair game. If you, after being fired, ask an employee at the company to take computers and delete stuff, that's fair game. But some of this other stuff, let's inflame the jury's heart by telling them that he beat up his brother during a meeting. I don't see how there is a balance there on that.
Well, threatening behavior, again, goes directly to demonstrating his ability to put his own self-interest at the expense of others, and that goes to the heart of honesty and integrity. The fact that there were many of these acts only indicated how defendant chose to live his life.
Yes, and counsel, you know what? There are trials every day where we have defendants who have a rap sheet a mile long. A mile long. They'll have 20 felony convictions on their rap sheet. And I see no judge say, go ahead, go to town on all of them, because they don't let you go into the facts. They usually just let one or two in. I mean, there is a balance.
But looking at what was let in relation to its impact on whether the jury could otherwise decide the case, not based on the fact that this is just a horrible person. That's really the balance, not what was let out.
That's correct, and perhaps if this involved a case that had 100 or 150 allegations, it would present a different scenario.
30 non-convicted, and they're not convictions, not one of them, acts. That's balanced?
Well, as you point out, the fact that they're not convictions, that they're just bad acts, if anything, makes them less prejudicial. But the fact that there were so many is only indicative of how defendant lived his life. The court was not required to unduly sanitize that.
Which proves the point. You're saying, this is just him, he's a bad guy. There's a lot of acts because he's just bad. So, to say it's indicative of how he lived his life, he doesn't get convicted because he's a bad guy. He gets convicted for these particular crimes. And that argument, I have to admit, it's kind of rubbing me the wrong way.
Again, he also filed a motion for a new trial. He argues that he received ineffective assistance of counsel during jury selection. Jury selection is a very important aspect of a trial. It's vital to do what you can as a defense attorney to make sure you have jurors who are committed to being fair and impartial, especially in a case like this. If Kelly can prove his lawyers fell short of an objective standard of reasonableness, and there's a reasonable probability that if it weren't for the lawyers' errors, the result of the case would have been different, then he might be able to get a new trial. Kelly also alleges that one of his prior lawyers had a conflict of interest in their representation of Kelly. Kelly had previously waived the conflict of interest. However, the motion alleges that this was an unwaivable conflict, and therefore Kelly was prejudiced by the conflict and deserves a new trial. It's worth it in this situation to make the requests. At a minimum, getting a new trial would give Kelly another shot at beating his case. His lawyers would have the benefit of having the whole trial transcript to plan their defense, ideally being able to shut down prosecutors' evidence. We'll see how the judge rules on these motions. And so that's it for now. Please like and subscribe if you haven't already. As always, I want to thank you so